Okay, well, we're back here with another short video lecture on litigation. This time we're going to talk about, basically, we'll spend most of our time talking about oral depositions, okay? Now, there are some other ways that this can be done, but quite frankly, they all kind of pale in comparison to the actual deposition where you have the party come in, have them sworn in, and then take their statement. Now the important thing in the form of like some background here is that these depositions are somewhat informal, and yet the person is sworn, like I said, or at least they have to affirm under pains and penalties for perjury that the statement that they give is the truth. And so the issue here really is that a person gets locked into their statement. And this is only available in a civil case for the defendant, but it can be very effective in terms of negotiation. If you take the defendant's oral deposition and they make any admissions against their own interest, this can be a very important bargaining tool in terms of settling the case, which is really the main goal of most plaintiffs' attorneys, and especially torts. But this can also be true in other things like mechanics liens, contracts, and things like that. So here again, look carefully at the whole concept here. What's the background? What's the reason? Why are we doing this? Another important thing on the deposition, remember what I said earlier when I talked about discovery, and that is never log somebody in or require them to appear for a deposition if you haven't done your other discovery first. So it's important to have them served with interrogatories, answer those interrogatories, because here again you can probably catch that person in a lie. It's very possible. I've done it many times. Now, one further thing before I throw myself into the formal part of this is that the question comes up, you know, can we just depose an eyewitness? You know, well, this is something that you really cannot do without a court order. You can depose the parties, no question asked, because they're a party to the lawsuit. They've got to be willing to participate in every way in that lawsuit, and they've got to do whatever it takes to get the case resolved. The court's going to require that. But when it comes to an eyewitness, where it'd be an imposition, the person is not available, for example, you know, this can be more problematic. Now, I will say this, that the doctors, for example, that are going to appear as expert witnesses, and I've talked about this before, often much prefer to do a deposition. So, you know, that is usually done after working hours in their office. A lot of times it's very effective because you got them sitting at their desk. They've got maybe a light box where they can show the x-rays and explain what happened. A really experienced doctor that's done a lot of testifying can be a big asset in a personal injury case, and very important. Another place that they can help you a lot is in Social Security hearings. And sometimes that can be resolved just with a letter, but sometimes the court wants more of an in-depth explanation, and that's administrative court judge, so you might need to take you know, the deposition of the doctor in that case. One thing is that the rules of procedure are relaxed in these administrative hearings, so it's a lot easier to get statements from doctors and so forth in those type cases. One of the things that we want to also talk about is that in your materials there is actually a copy of an oral deposition. One of the people that was involved in developing this course included a deposition, change the names to protect their identity and so forth. But I mean, this is very important. And what the important thing is here for your trial notebook is you're going to need to summarize this. And one of the things I've found with students where this is really a problem is, you know, let's say this is a 20-page document. Well, don't give me a 20-page summary, okay? You've got to boil it down. What's important? You know, is the fact that they went to school at Hendrick School important when they were 5, 6 years old? No, that's not important. The factual information is what's important. Now, sometimes some of that unrelated stuff that goes to credibility can be important. How many times have you been divorced? 5. Okay, well, what would your wife say about you? Well, they would all say I was terrible, I was mean, I was rotten. Okay, so, you know, some of that stuff can come into play. But usually, formative things like where did you go to first grade? And it's in there. Believe it or not, a lot of times you'll find that they include stupid stuff like that. And their only real purpose in that is to pad the deposition. But sometimes they try to argue, well, we want to show your ties to the community, that you've lived here a long time. If you grew up in Alaska, for example, some people like that, juries may not think they're as credible because they've moved around a lot. Now, the fact that their father was in the Army, you know, explains it away, but, you know, they'll try to use anything to make you look bad. So these are the type of things that are in here. So one of your assignments is going to be, you know, break this down, put it in your trial notebook as a summary of this deposition to just prove to us that you know what we mean when we say summarize. In other words, get me the important points if I'm going to try this case so I can have the important points at my fingertips. Other thing is we're going to need to know line and page, line and page. So at line 13, page 3, he says, yes, it was all my fault. What do you think? Think that's pretty earth-shattering? Yeah, I would say so. Once I did that summary, I would highlight that. So when the attorney looks through it, you're saving him a lot of time. He doesn't have to read the whole thing if he can count on you to do a good job of summarizing this document. The other part of it is, when he's in the middle of the trial, he doesn't want to have to flip through the entire deposition. Where did that guy say that? You know, he wants that right at his fingertips. Okay, well, some other quick points. As I said, oral deposition, the most preferred type. There is another type called deposition upon written questions. The thing about the advantage of an oral deposition is you get to see how they operate under oath, and you kind of catch them off guard, so you're getting to test their credibility. And then in other things, that like with experts, like I said, you're preserving their actual testimony where they may not be able to appear. Like if they've got a heavy surgery schedule, you don't want to take them away from surgery in order to testify in your tort case. So that can be an issue. So understand that there's actually 3 modern types of depositions now. I said there's oral deposition, everybody meets in an office. There's also deposition on written questions where you compound the questions and you provide them to the party. And then they have time to go run around and research the answers. And then, so that's why it's not very effective. You lose the kind of ambush effect of an oral deposition because they have time to think about their answer, they have time to find the answer, and so forth. The third type is something new. We've been doing this for a few years, but it's really gotten to the place now where you can use like GoToMeeting software on the internet, and you can actually have the party in the law office of his lawyer in one city, and the court reporter can be in that same office with the lawyer and the party, and then the like the plaintiff's attorney can be in a whole nother city halfway around the world, basically clear across the United States. And so the attorney can ask the questions through the internet, and then the person will answer. And usually there is a camera hooked up, just like the one that I'm using right now. And so there's a combination of video and then the electronic type of deposition where you're actually taking the deposition through the internet. And then what ends up happening is the court reporter reviews the entire proceedings again and then certifies them as that's the truth that was on that e-deposition. And then also they can also act as a videographer sometimes if you get the right one, and then they in turn can be the person that certifies, yes, everything on here is the truth. So then the judge will accept it, because to be a court reporter in Indiana, there's really only one real requirement, and that is you have to be a notary public. So that's the key to the whole thing. Now, different states have different rules. There is a formal certification process for court reporters, and there is a school for that in Indianapolis, and most major cities have a court reporting school, and it can be a very lucrative opportunity. So actually, I've had paralegals go out, get their notary, and become court reporters, which you can do without even going to court reporter school. Or you can go to court reporter school and have not only your paralegal degree, but also your court reporting certification, which is like another year, and then be a notary public, and then you could actually do depositions. So once again, this could be a good opportunity for you to find work if you're looking for certain kind of work. And it's one of those things you can do on your kitchen table. So you can just put an ad out there, have a phone, and then go to the lawyer's offices and use their office, their conference room, or you can work out an agreement with someone that rents out offices, that you could just use an office when you need one. Just use the conference room when you have a deposition. So there's a lot of things that you can do nowadays in this field as a court reporter, especially in Indiana, where you only need to be a notary public. So this is a good opportunity. I'm always out there looking for opportunities for you, so just so you know. So usually a court reporter is either a trained court reporter, like I said, that's able to swear people in as a notary public, and then they take the whole record and they type it down on that little tiny typewriter. Most of the people that you'll see in this now today, though, is that they just use a tape recorder. Some of them are kind of funny. They're really old and kind of shabby. Others are like brand new. I mean, very nice, I'm using a flip camera right now. That would be perfect for this type of work. I mean, because you could get the video and the audio, and a lot of lawyers now want the video. And if you could do that, and that'd be your way of recording the whole deposition, for example, that would be terrific. Now, we're going to work on giving you a video of like a faux oral deposition that we're going to do, like in a conference room here in the next few days, probably within the next week. But for right now, just try to imagine that there's a room with a table in it, at least two lawyers, at least one witness, sometimes both parties are there, the plaintiff and the defendant, and always a court reporter. There needs to be a court reporter present to swear the witnesses in. Now, I've seen in some little small towns, they actually do the deposition, have one of their secretaries type it up and certify it, because she also happens to be a notary. But that's really not what's called for in the rules. It needs to be a neutral party that doesn't work for one of the lawyers. I don't think I would go. I mean, it costs a little extra money to have a neutral party do the deposition, but I think that would be better than agreeing to have one of the attorney's secretary act as a court reporter. I don't think that's a good idea. Some people do that. A lot of small town lawyers, they do it. They just all agree, well, we're going to save some money because we're just going to have our secretaries act as our court reporter. Well, that's good for them, but I just don't think it's a good way to go. Okay, so it's usually recorded, at least recorded on audio. It can also be recorded on video, like I'm telling you. In the old days, I had a case one time where I went clear to Denver to take a video deposition, and the camera was like this big, and I had to get it through security in the airport. And so I remember I even had packed it styrofoam and stuff, and they're like, well, you've got to untape that and let us see what's inside it and all this, and it was this big, you know, just like that fishing story, this big. And the other funny part was that thing cost me $1,000, and the one that I'm talking to you on now is 10 times better. It cost me like 90 bucks. So, age-old story. And it's about the size of a telephone. Tiny little thing. So, great. Couple things. Sometimes depositions can be inconvenient. Like I say, it can be an imposition on witnesses. They can be expensive. They're very time-consuming. You can reveal your case strategy. It depends on what your strategy. Are you trying to settle the case, or are you trying to try the? You want to have a trial? Then, you know, depositions aren't really that good for you. There is a rehearsal of testimony, and so there's a lack of spontaneity. There's also sometimes a lack of authenticity. So this can be problematic. E-discovery, it's a good way to go if someone's going to be unavailable, that you can go across country. Guys in the military, for example, you could take his deposition at a location. Here again, you'd have to work out the dynamics of, you know, would his attorney be there in the room with him in Seattle, and you're in your office in, let's say, Indianapolis. I don't know. These are things you have to work out. But you can use those digital cameras. You can use the type that just fit on top of a monitor on a computer. There's a lot of different options. One of the things, when it's just at least been my experience, that when you use a camera in an electronic deposition in this type situation, you're only going to get about the upper body, more or less like what you see of me from the waist up. You're not going to get like the whole person. But you know, usually that's plenty. You can get facial expressions, hand movements, gestures. Do they look like they're telling the truth? You know, these type things are all important for a jury if you're going to show that in lieu of a person's testimony, which that's what I did in that Denver case, and it was probably the key to winning the case. People have actually done telephone and cell phone depositions, where in the old days we'd even hook the cell phone into a recording device and just have it go into the recorder. But nowadays you don't even really need that because the phone itself can act as a recorder as well as a telephone. Very efficient, somewhat time consuming, but saves a lot of time and money. And here again, it's all based upon what the parties will agree on. If the attorneys can agree on that, then that's a good way to go. Here I said, you know, webcam, another option, telephones, you know, this type thing. Problem that you get into sometimes if you, you know, get too small of a shot, where you're just getting maybe just the face and not the hands and the body movements and stuff, then you don't get quite as good of a read on what the person's you know, attitudes are and whether they seem truthful or whatever. Other thing, electronic transmissions can be hacked. A big thing on that you've got to worry about is just technical difficulties altogether. Does it get lost out in the ether somewhere, out in you know, outer space with the internet, or what, you know? Here again I said, like GoToMeeting and a number of these other products are out there. One thing that's important about a deposition is the notices. You can see there's notices. You also want to send out a subpoena. Tell them where they need to appear. A lot of times they're not going to appear at the courthouse. I've done depositions in the courthouse, but you also could do depositions other places, like in your office, for example, or in the opposing attorney's office. So these are things that need to be worked out, and they need to be put in the notice, and they need to be served on the person, usually if they're a party, just by regular U.S. mail. Okay, so this is important. Well, defense of a deposition is tough to do. A lot of times you can make objections. Some of the questions can be leading, they can be overbroad. You can, you know, someone can repeat the same question over and over again. Another good thing for an attorney to do, if you know that your client's going to have to be deposed, have a pretend deposition right in your office, just to practice, so that you can try to work with them and so they won't blurt out things that are not in their interest, like have them say, "It's all my fault, I don't know why this happened," you know, and this type thing. So a big important part for the paralegal, sometimes, especially in some of the cases, paralegal will set up the equipment. If, on the other hand, you know, you've got an agreement where the staff of one attorney is going to do that, then a lot of times that stuff can already be done. Your big role for a paralegal in this, if you're going to sit in on it, is that you need to take notes and your observations. Does he seem honest? Did he seem nervous? You know, what do you think? Also important that you can look for is compare your notes to the actual transcript, see if you find errors. I've actually found really bad errors, whole words that are misunderstood, that change the whole meaning of the deposition. Just one word can totally affect the whole outcome of it that they get wrong. You've got to catch that stuff. And that's where paralegals can be the detail person. Lawyers are usually broad strokes, you know, hey, you know, got to get to another courthouse, you know. So that's where the paralegal needs to go through. Big thing for paralegals is that deposition summary, like I told you. That's your critical thing that you can do, is boil it down, and you always want to get the dates on there, get the events on there, the page number, and if possible, the line number. So you get page and line number, very important. Okay, well that's the main points I want to cover on the oral deposition for our civil litigation class. Hope you enjoy it. We're going to actually do a mock deposition here in a few days, and we'll have that up for you to look at. It'll probably be in the same discussion board, so keep an eye out for that, and we'll hope to have that for you in a few days. Okay, well enjoy, and we'll get back with you again with something new.